Good afternoon, everyone. And on behalf of Heritage Title, welcome to our industry update this month. Thanks for joining us. As I always do, I want to remind everyone about our upcoming updates. I want to draw special attention to one that we did as kind of a special or bonus update that's taking place next week on Tuesday. You all have seen the flurry of posts on social media, and there have been lots of discussions about all the new property valuations that have come out. And we're going to have Toby Domish, who's the sitting Douglas County assessor, is going to be talking about the appeals process and how that works. So I just sent an email blast on that a little while ago. So sign up for that if you're interested in learning more about that process. So then you can turn around and share that information with your clients. And then we've got a wonderful lineup, as you can see, for the whole rest of the year. We've got lots of attorneys, and we've got legislative updates, contracts and forms. There's going to be some interesting changes to those coming up. So make sure and save the dates and invite your friends, and we'll look forward to seeing you on some future updates. And with that, like I said, I am not going to do a big intro because everyone knows Marcia. You don't even need to hear her last name. You just need to say Marcia to real estate brokers and they know who you're talking about. So
and they cringe with fear.
So we really appreciate, Marcia, your time as always. We always eagerly await your updates, and we can't wait to hear what you have to say. So thank you for your time today.
Well, thanks for having me. I'm just going to go over kind of what we've been dealing with. I'm not going to go into the full-blown forms changes, but I do want to put on everybody's radar that how the forms process works, some of the challenges that we've been dealing with as far as the legislative session is concerned, and then what to expect when the forms go in front of the Real Estate Commission in June. So just with the forms process in general, all of the commission-approved forms are on a 3-year cycle as far as if we make changes and the commission adopts them and then we publish them for 3 years, those forms remain out there for you to use. And that way you've got continuity, sorry, it's been a long day, continuity, stability, and you can properly identify if there's anything broken with the form. You can submit suggestions for us to make changes. And then when the 3 years is up, if there's changes that need to be made, the year prior to that 3rd year, the forms committee will start working on them, and then we'll present them to the Real Estate Commission again for adoption of any changes that are required. Some forms are pretty stable. They don't need to be changed within those 3 years, but we've got the 3-year moratorium just so that you are able to use the forms without them constantly changing. And the constant changes when we previously did them kind of on an annual basis really kind of created a lot of disruptions because a lot of people couldn't keep track of why the forms were changing, the magnitude of the changes, and the implications. So, and with the suggestions process, form suggestions, a lot of people will email them directly to Kent or Damian. You can email them to me. We actually have an email link where you can submit forms changes. We've got a survey on the website that you can submit forms changes to. Regardless of who you send them to in relation to the forms committee or the division, they get placed on a global list. And then every year, usually in about October, Kent, Damian, and I will sit down and go through the global list. Then in November, we will take the suggestions to the forms committee. The forms committee kind of refines what they think should be worked on. And then we'll present them to the commission in December. And the commission actually gives us direction on what we're going to work on. So that's how they determine what moves forward and what changes happen. There's 3 reasons why a form would rotate out of the 3-year moratorium. One is if the Attorney General's office noticed something heinously wrong with a form, which that is really improbable. That's going to happen because the Attorney General's office serves as a general counsel for the Real Estate Commission. We use them to litigate our disciplinary cases and also provide legal guidance. They don't play a regular role in the forms creation themselves. So I haven't seen it happen yet that the AG's office has necessitated a forms change. The second reason is due to case law. And that's more probable than the AG's, but it doesn't happen too often. The third one is the legislature. And Usually we do a good job, and we rely kind of heavily on the Colorado Association of Realtors because they're over at the Capitol and their voice seems to be heard more than ours is. But anytime the legislature tries to cure some social ill through the real estate forms, what we try to communicate to them is that we have this process, and changing the forms is really disruptive to the industry and also the consumers, and that we've got a process, and please follow that process rather than legislating changes. Unfortunately, that has not been the case this legislative session. So originally what the Forms Committee was tasked with dealing with, as directed by the Real Estate Commission, is they were supposed to do some cleanup work on the earnest money receipt. They were going to work on the manufactured home contracts. There's a benchmarking disclosure form for commercial properties that are over 50,000 square feet. That was a form that was requested by CDPHE and the Colorado Energy Office based on some legislation that was passed last year. And then the Real Estate Commission wanted the Forms Committee to work on addendum for the seller's property disclosure for brokers to use when there's an additional structure on the property. So if you have a house and an accessory dwelling unit, what would happen is you would fill out the SPD to deal with the main house, and then you would use the addendum to deal with the ADU disclosures. So we were doing great. Everything was kind of above in the process, and I mean, we were actually going to present the Real Estate Commission with the addendum for the seller's property disclosure. We had anticipated that it would be kind of long-term. This would just be something that we would work on throughout the year and maybe look at including it in the forms for adoption in 2024, but it's in a good shape, and it's something that we plan on introducing to the commission next month when we do their non-rulemaking hearing. And then there were a couple pieces of legislation that have interrupted our 3-year moratorium on some forms. So there was a bill passed about metro districts, and that has pulled the contract to buy and sell out of the 3-year cycle. And that requires that there be the website link to the metro district included in the contract to buy and sell. And now what we are kind of working towards is a bill that's pending, and this is the last week of the legislative session, and they are going like gangbusters. But there's a bill on radon disclosures that was kind of unique when it started off. Fortunately, they have made some changes to it, because originally this radon disclosure bill put some responsibility on the brokers for non-disclosures by the sellers regarding radon. And we talked to them and they took that out. And we also discussed a few other issues about what they were proposing, but it's not just going to be a basic disclosure that Colorado has radon in its soils. It's got to be disclosed in 2 different contracts. So it's going to be in the contract to buy and sell, and that's also going to the seller's property disclosure. It's not just with sales, it's also with rental properties. But as typical with the disclosure language in the contract to buy and sell, you've got all caps, bold font about the horrors of radon. And then in the seller's property disclosure, it kind of gets into the weeds as far as what the sellers are required to disclose. Like, it wants the make and model of the mitigation unit if it's been mitigated. And we try to explain that a lot of sellers, you can't tell what the make and model is. So I think that's going to be kind of a challenge for them. And on that note, what I would reinforce for the brokers is that you do not fill out the seller's property disclosure, the seller does. And I guess if they don't know the make and model, they need to indicate on there that they don't know the make and model, and go from there. But there is non-disclosure liability issues. So this is not something that they can just ignore. They were trying to treat it like lead-based paint, and lead-based paint is a federal law. This is a state law. So it's going to be kind of challenging, I think, to navigate these changes when they go into effect. The bills pass through both chambers of our legislature, and it's waiting for the governor's signature at this point. And I will say that one of the things that we have been trying to communicate to the legislature is to let them know that, number one, the Real Estate Commission isn't mandated by state law to create these forms for our brokers to use. We do this as a public service so that you guys have consistent forms. You can get consistent education on them. They're available to you without having to hire an attorney. And likewise, consumers are familiar with these forms. If they're going to continue to make legislative changes, and unfortunately with the radon bill, this was a private interest group that got these changes made. We don't create forms for private interest groups. We create forms for buyers and sellers to be able to transact real estate business in Colorado with the help of our licensees. So one of the messages that we've been conveying is that this is a voluntary service that the commission performs. There's a lot of work that goes behind the scenes in promulgating these forms. And if this is how they're going to be used, then at some point we're going to have to look at the impacts on our resources, and we just may not promulgate forms anymore. And what that means is, and also Colorado is one of the few states that actually promulgates its own forms. If you look at other states, and I use Wyoming just because they're our northern neighbor, and I've had a conversation with their previous executive director, it was years ago, about how forms work in that state. So the way it was working in Wyoming when I had this discussion is the Wyoming Association of Realtors promulgated forms for their membership to use, which is great if you're a member of the Realtor Association. If you're not a member of the Realtor Association, what happens is if you don't have forms to use, that can speak to your competency to practice as a real estate broker. Here, what I would say is you would have the option of having a trade association produce those types of forms if we didn't promulgate them, or you would be having to look at, like, CoBar purchased, I think, Bradford Publishing. So CoBar might be able to produce forms for real estate brokers to use, or you're going to have to hire an attorney, which means additional expense for you guys to practice. So this is not a light kind of observation to convey to the legislature. It's more for them to follow our process, which is working, because I think there is genuine value in the forms that we produce. And we don't necessarily want to get out of the forms business, and it's not really a business for us. I mean, we do it for free, and it's a lot of work. And I think we owe a lot to the volunteers that serve on the forms committee, but you cannot misuse the forms just to promote somebody else's interest. And that is hopefully the message that we'll get across as a result of this legislative session. So what will happen next is, once we get the forms in basically finalized format for them to go to the Real Estate Commission, is we're going to hold a non-rulemaking hearing meeting on June 20th, I believe it is, with the Real Estate Commission for them to review the proposed changes to the forms. And if they adopt them, then what we do is we go into the process of reviewing the forms and making sure that there's no typos, no errors. We finalize the forms, and then by October, we try to have them published on our website. We also try to push them out to the educators and the publishers, so that you can get education, you can review the changes before they go into effect on January 1st of 2024. So that is the forms committee's process, kind of in a nutshell. If you do have suggestions on forms changes, like I said, you can email me directly. Or rather, instead of doing Damian or Kent, I would appreciate if you could go on the website and fill out the survey so that we can monitor it that way. But anything will work as long as it's submitted one of those 4 ways. There's another piece of legislation that we are dealing with this week that just kind of landed into our lap this week. And nothing has been finalized yet. There's still 2 days left in the legislative session, but it looks like Division of Real Estate is going to be tasked with doing stakeholder engagement for HOAs and metro districts. Included in the bill is comprehensive law review related to the Colorado Common Interest Ownership Act and any other laws pertaining to HOAs, including a uniform act that was published in 2021. Then we also have to deal with metro districts. We have to produce a couple reports that I think really serve to guide the legislature on what type of legislation they need to run. That hasn't even kind of cleared through both chambers yet, but this is something that these amendments to move it into real estate happen on the 3rd reading, I think, in the House. So we are scrambling to deal with that this week, and that may be something that we're going to have to deal with. There's a few other pieces of legislation that are impacting the real estate industry, and as the legislature winds down, we'll take a look at what the final bills look like, but that's an integral part of your annual commission update course, is just to give you an overview of what the legislature's done, because a lot changed in the real estate industry, compliments of some bills that were run. So if you own an investment property, I don't think life has gotten easier for you this year. And also potentially, because of the affordable housing issue, there was a bill that was introduced that basically, say like I owned a 10-unit apartment complex and I decided that I wanted to sell it. There was a bill that was making its way through the legislature, and I don't know where it's at now, but it would give a government authority the ability to decide whether they wanted to acquire that property for affordable housing, which the government doesn't operate in the same timeframes as the private world. So again, this could create some issues, particularly if you're an investor and trying to unload a property quickly. So stay tuned for that. Those will appear in your ACU. But things I don't think have gotten easier for you guys this year based on legislation that was passed. And then you also have to deal with what is going on at the municipal level. So this kind of takes me into some of the common license law issues that we have. And I will start off with competency, because competency deals with several different issues. It's not just, I'm a sales broker and I want to go do property management. What do I need to do to be competent to do that? It also is speaking to geographic competency and also your knowledge of those local ordinances and state laws. So, we get a lot of complaints about brokers going kind of outside of their geographic region. Just because you venture out of your geographic region doesn't mean that you're automatically incompetent to practice. You need to take some steps to gain knowledge about the market where you're practicing in. But what we've seen happen at the municipal level, particularly in different areas of practice, is like with septic issues, there's different septic regulations depending on the municipality that you are looking at doing real estate in. The latest trend has been with local property management licensing and also short-term rentals. So Denver's got a licensing program now for property management. I think Boulder's got one. Fort Collins is looking at one. Last year, Loveland was looking at getting involved in the Metro District disclosure arena. So because of these local regulations, that just kind of, you've got to make sure that you're educated on those, because you cannot claim ignorance is bliss. We don't enforce those local regulations, but if you violate the regulations and we get a complaint into the Real Estate Commission, if we are investigating that complaint and it becomes obvious that you were completely oblivious to those regulations, what the Real Estate Commission can say is that you were unworthy and incompetent to practice real estate in such a manner as to endanger the interest of the public. So be careful of those. I brought up short-term rentals, not because you have to have a real estate broker's license to do them, but a lot of our real estate brokers are involved in short-term rentals. And there are some communities that just will not allow it. So just make sure that what area of practice that you're going to practice in, you are well aware of the local, state, and federal regulations, along with your ability to meet your brokerage duties in performing those tasks. And another thing that I have that has not come up very frequently, but it comes up from time to time that falls under competency, has to do with when you decide to take on additional duties that you're not qualified to do. So an example is I think it was a couple months ago at a real estate commission meeting, we had a case that was filed because I think the listing and the buyer's brokers were out of the same real estate office. And so the buyer's broker was working with an out-of-state buyer. He was coming in from Oklahoma, and I think the property was in the Sterling area. And he was worried about meth contamination, and he'd asked his buyer broker to swab the property. So she schedules basically a preview or something. The buyer's not with her. She swabs the property, has the swabs come back as contaminated. And now you've got, the buyer wants out of the contract because we've got contaminated swabs. Now, and this creates several issues. So first of all, to test for methamphetamine in the state of Colorado, you have to be an industrial hygienist, not just a broker that orders a swab kit off of Amazon. That is not going to work. So you've got the whole competency issue to collect that. I don't know what the reliability is on those swab kits, but because you have to be an industrial hygienist, my guess is that reliability is questionable. So you've got that angle where the buyer's broker has probably done something that they were not competent to do above and beyond their brokerage duties. that now creates an issue potentially for the seller and the seller's broker, because now we've got this notification that you've got contaminated swabs. Do I have to disclose that? And I don't think the real estate commission is going to give you a clear yes or no answer on what's got to be disclosed based on this internet purchased kit. But it creates issues pretty much for everybody involved in that transaction, along with the fact that you booked a showing to start doing tests on the property, and that really upset the seller as well. So if I was a real estate broker, I would not volunteer to do any type of testing that I'm not qualified to do. And when you start taking on those additional responsibilities above and beyond your brokerage duties, your E&O coverage is probably not going to cover you for them. So just be really careful of that. Same things goes with inspections from time to time. It comes up with, well, my broker said there was nothing wrong with the property, so I didn't have an inspection done. And then we start asking questions about, well, so what's the broker's qualifications to do a property inspection? So again, if you're not qualified, don't do it. And there's another moral to the story. I will tell you time and time again with commission complaints, anytime a broker agrees to go above and beyond and do additional duties above those brokerage duties that are outlined in the statutes, no good deed goes unpunished. So if you're going to offer to do them, you better make sure that you do them and you do a good job at it, because otherwise, if you don't perform them or you do a bad job, not performing them, we look at as false promises. Doing a bad job, that's unworthy and incompetence, but there could also be civil liability implications to you taking on those additional duties as well. So be careful about that. Another thing that I wanted to go over for you guys, just because this is a regular practice right now when we do financial audits, is so Rule 5.11 discusses how money needs to be handled for non-real estate brokerage activities. Non-real estate brokerage activities is anything that occurs outside of the license law. So that's your own investment properties that are managed outside of the brokerage. If you do short-term rentals, that would fall under that. We had an interesting case, which I'll go over here in a minute, but basically when you do those non-licensed brokerage duties, the rule says you've got to deal with the funds one of two ways. Either, and your office policy manual for your brokerage has to dictate what's going to happen. So your brokerage gets to decide if I'm out there managing my own investment properties, they can tell me, Marcia, you've got to put those tenant security deposits with the brokerage. And if that is the protocol, then the employing broker is on the hook for those funds and they have to do a three-way reconciliation. Now, the alternative is the brokerage firm can say, no, you are not running those tenant security deposits through the brokerage firm. And what that means is then I have to set up a trust account that provides all the protections that a trust account does. And that's where I have to place those non-brokerage funds, which for the most part, you only have to do a two-way reconciliation on that scenario, which if I only have one investment property, that is not an onerous accounting task. I've got a journal and I've got to reconcile it with the bank statement. So if my tenant pays a $1,500 security deposit, my journal reflects the $1,500 security deposit. My bank reconciliation should show $1,500 for that security deposit, and they need to equal. So it gets more complicated if you're doing short-term rentals because you're dealing with advanced deposits and everything else. But you have to know how to handle those funds and you have to put them in a trust account. You cannot float your money through the trust account, so your rental proceeds cannot go into the same trust account as those security deposits. That's commingling, and that will get you into trouble with the real estate commission. One of the interesting scenarios that we have seen with doing these, there's a couple actually. So we had one broker that had $16,000 sitting in his non-real estate brokerage trust account. And when we asked questions about what's the $16,000 for, the $16,000 he was holding for his neighbor because his neighbor didn't want his wife to know that he had $16,000. Okay, so not going to go down the road of the relationship issues, don't really care. Technically, he was handling the funds appropriately. $16,000, he was holding funds for another. Those aren't his broker funds, so they were $16,000 in a trust account. They've got to reconcile with the bank statement. That's one scenario. Another scenario that we have seen, and this speaks to an employing broker issue, and this kind of goes into the category of what I have been calling lately provocative business models, which usually mean they run afoul of the license laws. So we had selected an employing broker for an audit. She produced her bank account information. The auditors start looking and they notice that there are funds going in and out of these accounts, but they're going to other accounts. So we asked for the other accounts. She told us that's none of your business. Yeah, if you've got a real estate broker's license and you're holding funds for another, it is the commission's business and it's in law, and they can ask you for the documentation. And if you don't provide it, we can subpoena you. But what it amounts to is in addition to her real estate brokerage business, she was doing what we have politely called really short-term rentals. So what she was doing was she was renting out properties for a couple hours for people to go have extramarital affairs in. So again, not the morality police. We need to look at, if it had been prostitution, we would have referred that to criminal law enforcement, but that's not the scenario. So we look at how the funds are being managed. They were not being managed appropriately. There were some other issues. Ultimately, I think that broker decided to give up her license because the short-term rental business was more lucrative than her actual licensed real estate brokerage business. But we see a lot of diversity in what you guys are doing as far as holding funds of another, and you need to be aware that it doesn't matter that it can be completely not real estate related. Like the guy that was holding money for his neighbor, it still pulls you into the real estate commission's jurisdiction because you've got the broker's license. And we have a state law that says anytime you come into possession of funds of another, you've got to comply with our regulations. And the reason that I brought all of this up is when our examiners go out and audit a brokerage, they may ask the employing broker about all of the non-brokerage activity that the broker associates are doing, and then they will do audits on that. So just be aware, like if your brokerage firm gets selected and we start asking questions about your individual investment properties, if you get audited for that, you got to produce those documents. Not producing the documents is a separate violation. And really, I would just go through the audit and see if there's any ways that you need to improve your accounting rather than trying to ignore the commission and hoping that we go away, because we don't go away. So I mentioned provocative business models, and these are kind of outlandish, but it is kind of interesting what we have seen over the past few years. And also what we heard about when we did our financial examinations audit in January. So I think word to the wise is anytime you start to think about ways to how can I set myself apart from all of these other 51,000 real estate brokers in the state of Colorado, I would encourage you, probably if you've got an employing broker, whatever scheme that you come up with or plan, first run it by your employing broker. And if you don't have an employing broker, or your employing broker looks like they are going to have a heart attack over what you've pitched to them, consult a real estate attorney. Because typically, a lot of the times when we see a lot of creativity in how people are trying to set themselves apart, it usually means that they are not doing business in compliance with the license law. So like about 4 years ago, we had a real estate broker in the Colorado Springs area that her business model was to go out and do property showings in a bikini. It was really cold when she was doing this. We don't regulate your dress code. At least she was wearing clothes. And that's not something that necessarily falls within the real estate commission's jurisdiction. But then we had the broker that, as of last January, he started tweeting out that he was offering nude showings. No, we don't want to see the ring videos. We've seen a lot of ring videos between COVID and showings. Do not want to see the ring videos of that. There's no municipality in the state that I'm aware of that allows you to just cruise around town without any clothes on. And frankly, if I was a seller and that's what I saw walking into my house, I would be really upset. And my listing broker would get an earful about what happened in my house under the guise of a showing. And fortunately, with that case, we called the employing broker and said, hey, are you aware your broker's doing this? She wasn't. She took care of it. And she did what we expect the employing brokers to do, is they're kind of our first line of defense to make sure that the license law is being followed. along with all local, state, and municipal laws. So please wear clothes while transacting brokerage business. The other thing that I heard of, though, in the financial examinations audit was kind of this concept of, you know what, I've got these tenant funds, the security deposits, they're going to be there for a while. What if I start investing that money? And no investing. It goes into a trust account and it sits there and you don't touch it. Deciding to become an investment advisor, not only are we going to deal with the whole competency issue again about you're doing things above the level of your license, that could also result in us referring you to our neighbor in the Department of Regulatory Agencies, which is the Division of Securities, and they can actually pursue criminal charges based on what you're doing. So don't try to get creative with people's money. One of the things that came up was, well, what if I just put the security deposits in a certificate of deposit? Those aren't short term. I don't think any tenant, well, would willingly agree to, if I was renting a property for 6 months, to have my deposit placed in a certificate of deposit. So just don't do that. Just follow the basic regulations and don't be creative. So the next item I have has to do with disclosure of material facts and how to deal with inspection reports. And this has been something that's coming up quite a bit. The failure to disclose material facts is a regular complaint that we get. And typically what we are trying to ascertain with those complaints is, what did the broker know versus what did the seller know? Most of the complaints that we receive speak to what the seller knew and failed to disclose, not what the broker knew. And if it's a seller issue, we typically are not going to open that for an investigation. It gets dismissed at intake. If it's a broker issue, those do get investigated. And if it looks like there were violations, they go to the real estate commission. What we've been seeing a lot of, though, lately is you'll have a property that goes under contract with multiple buyers, and the first buyer has an inspection done, and for whatever reason, the deal falls through. It doesn't close. It may have been for inspection reasons. It may have been through financing. Who knows? But it closes, or it doesn't close. And then you've got second buyer that comes along, and second buyer finds out that the first buyer had an inspection done. And then they're making demands about, well, they're entitled to that inspection report. They aren't entitled to that inspection report. And how you deal with that is also going to depend on what your seller says. If the seller doesn't have a copy of the inspection report and you as the broker don't have a copy of the inspection report, I don't know how you're going to give that second buyer a copy of the inspection report. They need to go out and get their own. If the seller does have a copy of that first inspection report and buyer number 2 is demanding it, you need to have a conversation with your seller about whether they want to have it released. Regardless of whether they're going to give a copy of that inspection report or not, if they have a copy of that inspection report, you are now tasked with disclosing what is in that inspection report. So if they've identified 20 potential issues with the property, you now have to disclose those 20 different issues. And also your seller is going to have to update their seller's property disclosure after that inspection is done to identify the additional issues. But we've had a lot of complaints in where that second buyer is complaining about, well, I never got a copy of that first inspection report, and they're not outright entitled to it. And frankly, if I was a listing agent and I was functioning as a seller's agent and I gave out that first inspection without my seller's permission, I think that could set you up with an issue with the real estate broker or with the real estate commission as far as your brokerage duties are concerned. You still have to make the material fact disclosures about what's in that inspection report. But if your seller didn't authorize you to release it and you never had the discussion with it, I think that's something the real estate commission could come back and say you failed to perform your duties as a seller's agent. So just be really careful about that. The other thing is that when you've got that secondary buyer wanting that first buyer's inspection report, you don't know what that inspector's qualifications are. And I understand that people want to save money in these transactions. But as a buyer's agent, I would probably still be encouraging my buyer to go out and get their own inspection report. And that way they can also evaluate the qualifications of the inspector that they hire. We have seen cases where there's been multiple inspections done And I think this makes it challenging for the listing broker as far as, you've got one inspection report that says the foundation needs work. You've got a second one from a structural engineer that says, no, it doesn't. And it's not your job to reconcile those. What you then do is present both and allow them, well, if it's an inspection report, get your seller's permission to present it. Otherwise, you're going to have to disclose that there was an inspection done that identified foundation issues. Your seller hired a structural engineer and they say there's nothing wrong. Present them with that information, and the buyer then makes an informed decision about what they're going to do. But at the end of the day, your job is to disclose, and it is the consumer's job to do their own due diligence and decide what is of importance to them. I've got a couple more things for you guys because I don't want to run over. So one of the bills that was run through the legislature this year that we are not complaining about is Senate Bill 23-77, and this has to do with broker engagement contracts. This stems from some issues that we've been seeing. We've gotten about 8 complaints about this business model. I'm not going to say the name of the company because we've got active cases pending and we don't get to do that under state law, but I'm pretty sure most people know who the company is. So what it amounts to is this company appears to be targeting people that are in dire financial straits. And I think what happens is people start going online and searching, foreclosure cures, short sales, refinancing, whatever the case may be. And that leads them down the path of coming into contact with this company. This company's business model is to go out and have a homeowner sign an agreement. They give them fast cash, usually not even remotely close to the value of the property. And in return, the property is encumbered for a period of 40 years. And if the seller decides to go sell it, they either have to use that brokerage or they have to pay a commission to that brokerage. And what I've seen in the agreements, it's usually a 3% commission based on the market value as determined by that brokerage firm. So, for $1,000, a quick $1,000, you sign this 40-year agreement. With our property values, $1,000 is a drop in the bucket compared to what your property values are. And what we have seen is, so in general, consumers do not understand what they're signing. They don't know that they are now on the hook with this company for 40 years. Usually their financial situation doesn't get any better and they have to sell or they die. So then they're taxed with selling the property and they didn't understand that they have to use this brokerage. So what can happen is after they've listed with a real estate broker, this brokerage finds out and they start going after the seller for the 3% commission, or they can initiate foreclosure proceedings. And we've seen that happen against a brand new buyer that wasn't even associated with it. But it compounds the issues because usually like that $1,000 that the seller or the homeowner got to try to get them out of whatever financial emergency that they were in the first place, when that company comes knocking for that 3% commission, or you have to pay to get out of that agreement, then they're looking at $13,000. So it's very disproportionate about what the consumer gets versus what they have to pay. And I mentioned in one transaction, the seller closed on the property. Brand new buyers are there when the company finds out and then initiates foreclosure proceedings against brand new buyers. So this is a predatory model that we've seen affect a lot of people. As far as we know, based on one of our investigations, there's been over 800 agreements in the state of Colorado, and I think that was as of last year. So the Senate bill bans that type of practice. There is a second company that has emerged. Their model is a 20-year program, and that's not going to fly either. Fortunately, because of the way the real estate commission statutes are written, and because this company has a brokerage license, the real estate commission gets to look at it from a couple different viewpoints. So the license law says you can't have a listing agreement for longer than a year. There is case law, it's the Brackage case, that says they can be longer than a year, but you have to still be providing your license duties. And that's typically what you're going to see with a high-end property or commercial property. Continuing to perform your brokerage duties isn't sitting on a 40-year listing agreement waiting for something to happen. So that's issue number one from our perspective. Then you have unworthiness and incompetency to practice real estate in a manner that harms the public and then you've got dishonest dealings. So that was the way that our real estate commission looked at it. I will say that because when we started getting the complaints in, I had my counterparts in other states asking, hey, are you guys seeing this? And we have given some states some tips about how Colorado has been addressing this, because sometimes the beauty of the way the practice acts are written is if your license goes down in one state, it has a domino effect in the other states. Most of us have similar language that says if a jurisdiction has taken action against your license and it would be a comparable license law violation in that state, then they can discipline. So like we reached out to the state of Kansas to give them some guidance. This is a nationwide company that has been practicing. I think at the beginning of either February or March, they said that they weren't going to do this business model anymore. Yeah, that's nice. Too late. We already have cases that are over at the Attorney General's office to be prosecuted for us. But in addition to what the Real Estate Commission can do with this type of behavior, this will also trigger us to make a referral to the Consumer Protection Unit in the Attorney General's office. And really what they can go after is much more than just the real estate license. So I have been encouraging people that if they come across these, please send them in, because this is just additional stuff for us to deal with our cases, and also additional information for us to give to the Consumer Protection Unit. And then the last thing I have for you guys, so a lot of complaints that we get have to do with clear cooperation and ethics. The Real Estate Commission doesn't have a regulation about how long a property can be advertised as coming soon. Our big thing is what are the conversations between the listing broker and their client about the use of coming soon? Is the seller making an informed decision? And, is it to their benefit? Because if the sole reason for doing it is so the broker can double end it, that's a problem. But then again, that might be financially beneficial for the seller if they have a variable commission. But we're not out there enforcing that, well, she's had a coming soon sign in the yard for 10 days. That's not us. That is a local MLS rule. And if you have those types of complaints, you need to file the complaint with your MLS board, not us, because we don't enforce that. The other thing that we hear from, and usually this is from the public, is, well, my broker was unethical. And ethics sometimes fall within the activities covered by the license law. Like if you're unethical and you're stealing money, well, stealing money is within the Real Estate Commission's jurisdiction. Unethical, if we've got two brokers that are bad mouthing each other at a cocktail party, that is not the type of ethics that we have jurisdiction over. That is something that you file with the Association of Realtors. If they're a realtor, their code of ethics cover that. So I just want to save you like the frustration of filing a complaint with us on something that we don't have jurisdiction over, which is clear cooperation and ethics. And I think that's it that I have.
Wow, that was a lot. And the moral of the story is don't screw with Marcia if you're gonna go.
It's not me, it's the Real Estate Commission.
Yeah.
All right, should we tackle some questions? We've got some great questions that came in.
Sure.
Okay, so going back to the geographic competency. So why does geographic competency not apply to appraisers? In Pueblo, we see appraisers from Denver who have no access to the MLS, and their reports show obvious incompetency for the area. When we file a complaint, we're told they are licensed in the state and they are able to appraise anywhere.
So geographic competency does apply to appraisers as well, but just like with real estate brokers, the fact that they come from Denver and they're in Pueblo doesn't automatically mean that they're incompetent. But we do look, when we're looking at appraisers, we do look at their access to the market data, because that's a key criteria for the development of their appraisal. And if they don't have any access to the market data, that's a problem. I will say a lot of the time, though, they will team up with somebody else in that area to gain that market data. So they might not sign up to be a member of the Pueblo MLS, but they do have access to that market data. Now, if it's absent from the report, I wouldn't say that we're not just, that is not the response that you get from us, that they're licensed in the state of Colorado, and that's good. We do look at geographic competency.
Okay, what if an inspector says, quote, appears to be black mold, but no mold test was actually done?
I'm happy to answer this one.
Okay, because I was going to say, well, I would start asking questions about like what all do they know about black mold to start even going down that road. But I will defer to Damian.
I disclose it, guys. I mean, it doesn't hurt anything to say that previous inspectors said there appears to be mold. So let them do their own inspections. It's the problem here is not necessarily your license law, because, you know, from Marcia's perspective, she's going to look at it as well. Did you know, is there a material defect, and go down that road. But from my perspective, the second buyer that comes in and it turns out it was black mold and you didn't say anything, they're going to be looking to file a complaint against the listing broker and the seller who didn't disclose something that they were on quote notice of. And whether they're successful or not, I don't know. But you guys have heard me say this before. It's not about whether you win or lose. I don't want to play. So I would err on the side of disclosure.
Interestingly, we've got an active appraisal complaint that one of the components of the complaint was that when the appraiser did the appraisal, per the complainant, she's claiming that the appraiser said that this yellow staining on a kitchen wall was from meth manufacturer, which leads us to ask, like, how do you know that? Like, what? So, I mean, there are questions that we're going to start asking if you start making kind of like accusations. We're going to start asking, like, what's your knowledge of this?
Okay, Damian, please clarify on inspection reports. As a listing agent, they are often shared along with the inspection objection. Once that happens, does the seller have ownership of that report and an obligation to share it, or can they update the seller's property disclosure to include any findings that are not corrected?
I think the question is about the intellectual property, because for a long time, there's been this question about whether or not, you know, the seller has the right to share the inspector's intellectual property or their report. And the answer is yes. Once they've shared that report, unless the seller has signed some kind of non-disclosure agreement, they have a right to share it because it's a property report. They're not using it, you know, broadcasting it out or using it to create money or anything. This is, it's a disclosure and just a property report. But Marcia hit the nail on the head with this, is that even if the seller doesn't want to share it, you still got to disclose everything in it. And so I agree with her. You have to have that conversation with the seller about disclosing that report. I would encourage them to disclose it, because it's a heck of a lot easier to disclose everything in the report by attaching it than it is going through and gleaning, okay, what do I have to put in the seller's property disclosure now? So I would just tell the seller, look, we got this report, guys. I encourage you to disclose it and go that direction, because it just makes it easier for everybody to disclose in the seller's property disclosure. Marcia, you have anything to add?
No, I will say some of the inspection reports reminds me of like anytime a non-attorney decides to write something and then they let an attorney get at it, it's like, oh my God, did I write anything correctly? Some of the inspection reports that we see, it's like, wow, like why don't they just tear this property down based on every issue that the inspector has identified?
Yeah, which at the same time, I mean, you can deal with that with the seller saying, we disagree with everything in the report, but here it is. Or have their own inspection go through and say, we disagree with everything in the report, and here's our inspection that says that it's not nearly as bad as this guy thinks it is. It's just, there's ways to deal with it, guys. I like providing the report, but Marcia's right. You got to have permission from your seller before you start doing that. Otherwise, you're getting into, did you harm your seller by doing it? And did you breach your duties? So.
Okay, Bonnie, hopefully that answered your question. Let me know if not. Let's see, Jill asked, where do we send information on the 40-year listing agreements? There's a foreclosure in Beulah with one recorded and on the O&E report.
So you can file a complaint online with us, or if you don't feel comfortable doing that, you can send me an email. And then basically what happens is, please send me some sort of document that shows that there is that agreement, so that I've got some documentary evidence. And even if it's just, you can do it anonymously. Anonymous complaints, we open up on the commission's own motion. It says it's anonymous, but we will kind of pursue that from the commission's own motion standpoint. But I do need some evidence. It's just, you can't just send me an email that says, you know, 1234 Main Street has one of these agreements, because that's not something we're going to be able to look into.
And the O&E should have it on there, and it should be linked so you can, download it and then send it so that she has the documents.
Okay, so we had a few more questions on that specific issue, so we'll try to tackle a couple of those, and then we'll grab some of these other questions. So, and I will get over to Q&A as well, so you don't have to post both places, just so you guys know. If the first buyer walks because of the inspection and the seller doesn't get a copy of the inspection report, then the seller and the listing agent don't know the details of the report and can't disclose. So should the seller be asking for a copy of the inspection report, and should the listing agent be reading it all the way through?
I don't think you have to ask for it. No. I mean, if they tell you in the inspection objection that they terminated because there was a crack in the foundation, then you're going to have to disclose that. I mean, because it's in the objection. If they tell you that we're terminating based on inspection, but don't give you any details, then what I'd probably do is put in the seller's property disclosure for the seller, talk to the seller about this, of saying, let's disclose that they terminated based on inspection, but did not provide the inspection. Just do something to help help your seller insulate themselves, that they really don't know what the issues are.
Yeah, I don't think that's an issue to just say they didn't disclose why, but they terminated based on inspection. And hopefully it was good faith that they terminated using that, because the other thing that we see is you can tell from the motivations of, either the seller or the buyer, that they will start, like, things will start terminating, and it's not due to the actual condition of the property. The buyers got cold feet and they decided they didn't want it, but they use that as a reason to terminate.
Yeah, and a lot of times, but they might not provide the inspection report because of that. And so I would just, do what you don't have to ask, but you could give what you got. You got to give what you have. You got to say what you know.
There was a comment that the problem with disclosing an inspection report is that there are incompetent inspectors that can really harm sellers.
I think Marcia just said that.
Yeah. Okay, a couple people asked about the status of inspectors being licensed.
Oh, Marcia, you want that licensing in your division, don't you?
No, I think they've always sought to have it put in the Division of Professions on Occupations, and the home inspectors have actually, anytime the question of licensure has come up, they have sought to go over to that division because they don't want to be in the same division as a real estate commission. But as far as I know, there hasn't been any legislation presented recently for home inspectors. And probably at this point, if somebody was going to consider running something again, I don't know how long it's been since the last Sunrise application has been. So time may have passed that you would have to submit a new Sunrise application in order to even go down that road.
Yeah, I'd like to point something out. And Marcia talked about the Radon Special Interest Group that passed the legislation and the contracts. Just so you guys know, the reason that came about was because the year before they ran legislation that says that all radon testers or all radon inspectors now have to be licensed. And I think most of you know that as of July last year, that was a requirement. And the consequence of doing that has been that now radon tests are more expensive and less available. And so I get that we want licensed inspectors, or the people feel that we want licensed inspectors, but a byproduct of having licensed inspectors could be that inspection costs triple, quadruple, and then buyers decide they don't want to do inspections because it's too expensive. And then that leaves the broker holding the bag, because all of a sudden they're going to be blamed because they should have known, or they should have done this, or they should have advised. So I just want to warn you, be careful what you ask for.
And kind of on that vein, so I think if the governor signs the radon disclosure bill into law, I think one of the challenges, along with the whole disclosure aspect of it that you guys may face, is it's very much this, radon causes lung cancer. And as a buyer, if I didn't know any better and I saw that language, that would trigger me to go, I need to have this tested. And because of the availability, that may also push out your transaction deadlines, because you may not be able to get a radon test done as quickly as you previously were able to do.
Okay, so in regards to the company that has folks on the hook for 40 years, is there a good question we should be asking of listing folks to know if they could be involved in one of those situations? And are you seeing this all over Colorado or in just particular areas?
It appears to be statewide, and I would definitely, if you're sitting down with a seller and and when they're talking to you about their motivations to sell, if they're talking about, I got to move, I can't afford this anymore. I think in general, at this point, it wouldn't be a bad idea to say, hey, at any point, like in the past few years, did you sign an agreement where somebody gave you some money to kind of help you out? And if they say yes, I would start doing some research in on it, and probably refer them to a real estate attorney at this point. And especially when you're dealing with people that, like, for financial reasons can't afford an attorney, that's really when I would also encourage them to contact COBAR, because I don't know what these CLE requirements are, but at one point it was my understanding that attorneys got CLE credit for doing pro bono work. And I think this business model has been sufficiently offensive in many arenas that you can probably contact COBAR and find somebody to help them out.
The other thing to look at is O&Es. As Joe was talking about before, these guys were recording these documents against the property, which was creating a lien. And in some instances, it was the buyer that ended up holding the bag at the end of it because it was a lien against the property. Seller skips town, is gone, moves to Nova Scotia or wherever. And all of a sudden they go, well, buyer, then you're responsible because it's recorded against the lien and inures to the benefit of the successors and signs, which is a huge problem. So an O&E should pick it up if they're recorded. The one problem with the statute is that they could not figure out a way to make it backwards looking. So it's only going to be from when it's passed forward. So those things are going to still be in place until they work their way through the system or people are prosecuted or something happens.
But the real estate commission can do the ones prior to the governor signing that bill into law. I mean, I told you the three potential ways that we can look at it. So the commission's got the ability to deal with those issues. And I'm sure the consumer protection unit does as well.
Yeah, that's where it's going to have to come from though, because it's not going to be automatic.
I would add as well with regards to the O&E. I mean, if there is something recorded, yes, it should appear on there, but that's also a $5 automated, semi-automated report. So if you have concerns that there could be something like that in place, I would reach out to your title company directly. If you reach out to your rep, I would contact my title department, have them take a look at the actual chain of title, look at all the recording documents, and I'd have an examiner take a look at that just to make sure that there's not something in place. So, okay. Why was the Affiliated Business Disclosure Commission position statement deleted?
Because it's in the rules.
Yeah.
It's now a rule.
Well, and we've had rules for a long time. I mean, you've got the statute and also the rules. So
Yeah, they became duplicative.
yeah, well, and also, I mean, there are times, and competency is an example of this. There are times where something will start out as commission guidance through a position statement, but if the issue continues, provided that the real estate commission has the authority to do it, then they can adopt a regulation. And we typically don't want to have a regulation and a position statement that say the same thing. So that will then kind of kick the position statement out of play, and we will just focus on the regulation.
Yeah, and the rulemaking you guys did last time was so big that the position statements didn't get updated for a while.
I don't think, well, they were kind of updated piecemeal over the years, but we hadn't done a comprehensive review of them until last year, which has created a few issues, and we will correct those few issues that come to light. And the same thing with the rule review. I'm like, from time to time, you'll have a position statement, and I will use the position statement on property management. This was an issue that came up yesterday. So in dealing with a consumer, there has been back and forth with the division and this consumer about the claim is that the property management was embezzling funds. I'm not really clear on whether this is a management company that's licensed, which is another issue. But a new property management company has taken over the business for this consumer. and none of the security deposits have been transferred over. And it's been 30 days. So the consumer's now come back and gone, it's been 30 days, no security deposits. So if you look at the position statement says that you should be transferring copies of the agreements and the deposits. Those should go over to the new management company within 30 days. But then you look at the Real Estate Commission's accounting rules, and the accounting rules do not say that security deposits have to be transferred within 30 days. And then you you look at state law and it says within reasonable time. So that's kind of an example of where it's like, well, I think we might need to refine the commission's accounting rules because the position statement makes it look like it's 30 days. We need something more definitive in the regulations. So that's a rule that probably is going to be updated soon.
Okay, we had one more question in Q&A on the inspection report. What is your thought of listing brokers refusing to accept the inspection report?
Sorry, I think that's hilarious.
Well, it conjures up images of Monty Python and Run Away. I mean, still either in the termination or the resolution, the issues identified, you're still going to have to disclose those, regardless of whether you get the copy of the report or not. I mean, it's really something that you should talk to your seller about as well. Do they want a copy of it?
In my world, the attorneys will have a field day with the listing broker that says, oh, I got it in my email, but I deleted it and never looked at it, because they're not going to believe that ever happened. And they're going to have the email that says, well, you got it. You mean you didn't pass this on and you didn't tell anybody and you didn't disclose? And I mean, they'll eat you guys alive. So don't play the weevil of I see no evil, hear no evil, speak no evil. It doesn't work.
And the Real Estate Commission has had issues with brokers that do that of, well, it came in an email, I didn't open up the attachment, or I got a copy and I just threw it in my file. No, you have to look at it.
I like they respond and say, just so you know, I just deleted this and I never looked at it and I never opened it. It's like, oh, good. So you're admitting that you got it.
I haven't seen that specific scenario yet, but yeah, that's awesome. Not in a good way, not good, awesome.
All right, we are over our hour, and Marcia, we want to be respectful of your time. Thank you so much for that wonderful hour of great information and for spending the afternoon with us. We really appreciate you as always. Thank you, Damian. Thanks to all of you for joining, and we hope you got a lot out of today, and we will look forward to seeing you on our next industry update. Have a good rest of your week.
Thanks, Marcia.
Thank you.
Bye.